My name is Marie Kell. I'm speaking from Andrew Jackson Solicitors in Hull. I'm a partner in the commercial contracting team there. So today we are going to be looking at terms and conditions. So terms and conditions in particular in respect of consultancy. Now, I'm hoping today to give sort of a bit of an overview and I'm going to try and focus on some of the key clauses that will appear in terms and conditions. Some of them you may be familiar with, some of them perhaps you may not quite appreciate the meaning or appreciate the importance, but we are going to sort of focus on the key terms today. I'm also going to be looking at sort of current market trends and what businesses, certainly consultancy terms and conditions, what's happening with those at the moment. Obviously the hot topic is coronavirus and force majeure type provisions, and that is something that I will particularly focus on sort of later on in the talk. That's something that is obviously at the top of everybody's list that they want to know about. So if you are considering terms and conditions or certainly signing terms and conditions off at the moment, then this is something that you really do need to be thinking about. And as I say, I will pick up on that later. So the first point I really want to look at is sort of the benefit of terms and conditions. So it's a phrase that's bandied about quite a lot. Why are terms and conditions important? I suppose the first point is that it creates certainty. So with any legal contract and consultancy arrangements are included within that, you want to be absolutely certain as to what it is that you're signing up to, what it is that you're committing to. You also want to be certain about what's being imposed upon you, because there will be situations where it's not going to be the case that you can always impose your terms and conditions. What will happen is that you will be presented with contracts and you will be expected to sign up to these T's and C's. So in that situation, it's obviously even more important to be absolutely certain as to what it is that you are committing to. One of the key benefits for creating certainty, and one of the reasons why it's so important, is that it avoids disputes, or the theory is that it avoids disputes. If you sign up to something that is a bit ambiguous, a bit vague, then that is a gift from above for litigation lawyers, because that gives them loads of scope to argue about what the contract means. You want to be putting yourself in a position where what you're committing to or what you're being asked to commit to is absolutely certain. And then the hope would be that it would avoid any dispute, it would avoid any ambiguity, and it would avoid sort of anything for the parties to fight over, because what you've done is you've created a situation where you've created absolute certainty. Nobody can argue about that. Nobody can try and sue you or take you to court because it's ambiguous, because it's absolutely clear what it is that you've signed up to. So sort of going along hand in hand with that, it minimises your risk. If everything is certain, if you're reducing the risk of litigation, then that reduces your overall risk. And the knock-on effect of reducing risk is, one, well, it's a lot stressful, but also it can help with other issues, sort of monetary issues, and certainly it can help with insurance. So if you are looking to minimise risks, if you have a good and a well-drafted set of terms and conditions, you're certain what you're signing up to, then often it will reduce your insurance premiums. So it just means that you've got everything covered off and you're putting yourself in the best possible place for a successful business relationship. It also avoids you being sort of inadvertently bound by unfavourable arrangements. Now this is often a common situation, and again, I draft contracts, so I would try and put you always in the best possible place to move forward with business. Would always advise a well-drafted consultancy agreement. However, if that can't be the case and you are presented with a contract, the worst thing that can perhaps happen is that you sign off something that you're not sure about or that isn't favourable to you. You sign it off because you want the business. It leads to misunderstandings. It then is kind of the reverse of this slide. So it creates all the problems that we're trying to avoid. And it can mean in certain situations that you are stuck with unfavourable arrangements. Now, in sort of a best case scenario, unfavourable arrangements are never good. It can be sort of minor niggles, but in a worst case scenario, if you are signing up to contracts that perhaps you're not quite sure of the meaning and they have got, for example, horrendous indemnities in there, the contract can be almost uneconomic. So that's the absolute worst case scenario. You haven't got insurance to cover it. It can potentially put the business and put you as an individual into all sorts of financial difficulties. So you don't want to be inadvertently bound by something that ends up being unfavourable to you. So they're all the benefits. That is why you should do it. So moving on to sort of some of the key points that you need to consider and some of the key terms. I'm going to start with looking at this sort of the scope of work. Now, this isn't so much sort of a boilerplate legal term that you'd expect to see in terms and conditions, but it is something with consultancy in particular that really you should be focusing on. And again, it's an area that, if it's not done correctly, can potentially lead to problems and parties falling out. If you have a very, very, very clear scope of work that sets out what you are going to do, so in the situation where you are providing consultancy services, if it is absolutely clear what that scope of work is going to be and what you are warranting against, so you have a consultancy agreement, for example, that warrants that you will perform the services in accordance with the schedule. If that schedule is all a bit vague, all a bit woolly, doesn't commit to anything in terms of timescales or obligations, then that is potentially going to be a problem for you, because what will happen is the person that you've signed the contract with will come back and say, oh, I expected you to do X, Y, and Z on Wednesday. And you will say, no, that's not what we agreed. I agreed to do A, B, C on Tuesday. And it's how do you come to that resolution if you haven't got a clear scope of work? So consultants in particular, one of the key things that we try and focus on is making sure that the scope of work is clear. You're warranting against that scope of work, and the operative provisions are that you will provide the services, you'll perform the consultancy services as described in a scope of work or an SLA or however it may be structured, but you've got some document that sets out clearly what it is that you will do, when you will do it, and what standards you will do it to. And if all that is a bit loose and a bit vague, then that's when it can lead to fallouts. So there are very clear benefits of having a defined scope of work, because it reduces all these problems. And also it's good contract management that you have set out somewhere very clearly what it is that you will do. So it is managing everybody's expectations as well as minimising the risk and putting you in a strong legal position. So that's sort of the first point that I'd like to start off with on terms and conditions. Always think about the scope of work. And honestly, a lot of that is commercial detail as well, and that is something that you would do yourself. You wouldn't need a lawyer to do that. But if you get that wrong, then the rest of the terms and conditions can potentially fall down. So that's scope of work. So moving on now to sort of the key operative provisions. Again, I've obviously only got an hour today to talk to you, and there's lots of key provisions that would go into a consultancy agreement. What I've tried to focus on is sort of the main ones that I think you'd be particularly interested in. So what I'm going through today is not an exhaustive list by any stretch of the imagination, but it should hopefully highlight some of the main points that certainly I come across and I see in reverse, if it hasn't been documented correctly, where it can go wrong. So the first thing that you need to be thinking about and talking about and then documenting clearly in the contract is the term and termination. Now, this sounds very, very basic, but often there are lots of sort of pitfalls that can happen with this if it's not done properly. So if you miss this bit out and it's not clear how long the arrangement will last for, then that has knock-on implications for nobody's sure then how long you've agreed to provide the services for, no one's sure how long you've agreed to be bound for, and importantly from your perspective, nobody's agreed to pay you for the duration of the time that you're providing the services. So always really be very, very clear about, is the arrangement going to last until the services are performed? Is it going to be for a fixed term? How are the parties going to get out of it? Is it going to be a structure where you'll agree for a 6-month period and then it will automatically come for an end? Or will it be that it's a project by project basis? Will it be that it will last for 3 years until either party terminates on giving notice? Always think about that structure and make sure that it's documented. Now, the common triggers for termination for when it's automatically terminated. So this is not the situation where the contract's just come to an end and you've performed the services and that's it. This is a situation where the contract is ongoing and either party sort of needs an option to get out of it. Now, the common triggers for termination here are breach. So one party has breached the contract and therefore it automatically comes to an end. So if you were providing services, for example, and then for whatever reason you just decided to stop, then the other party would be able to sue you for breach of contract and terminate because you hadn't done what you'd said you were going to do. Equally, you're providing the services, you're doing everything that you said you do in the contract, you've got a clear scope of work, and they stop paying you, then again, that's potentially a trigger to terminate the contract. You want the contract to come to an end, you want to terminate for breach, and you want to be paid for everything that you've done up to that point. So these are sort of the quick triggers. So it's very, very standard in terms of conditions, and you would want this to allow both parties to terminate instantly. So irrespective of how long the contract's going to last for, you can terminate instantly if there's a breach by either party. If either party goes into insolvency, so depending on who the contract is with, it will either be sort of corporate insolvency or it will be personal insolvency. Or in the case of consultancy arrangements, it can be death. So if the consultant, if it's one person performing the services and the consultant has suddenly died, then again, that's something you don't want them to be left with a contract that's just hanging. You want an automatic right to get out. So these are the kind of things that you should be thinking through. If you are signing off a contract and the other party won't agree to early termination for breach or insolvency, then that would ring some alarm bells for me, because these are very, very common grounds for termination, and these are the grounds that you would want to terminate in these circumstances. The other reason why, and this is the final point on the slide, why it is important to have a clear term and termination clause is what happens in the situation where there's unsigned contracts. Now, this is a bit of a, this is something that is commonly misunderstood. So often people will think, well, we've kind of agreed a draft, we never got it finalised, we never got it signed, so actually we're not bound by this contract. What will happen, and people often say to me, oh, well, we never signed it, so it's absolutely fine. But the reality is that the law will say that even if you haven't signed the contract, if you are complying with all the terms of the contract, and if the other side are complying with the terms of the contract, so if the situation is that everything is going along as if the contract is in place, then unfortunately there is a high chance that you will still be bound by that contract. So even if it hasn't been signed, if you've been performing your obligations, they've been paying you, or the reverse, if the situation is the other way around, then that contract will still carry on in full force and effect, and you will still have to go through the process of termination if that's what you want to do. So I suppose in respect to this area generally, what we're saying is there needs to be clarity and some certainty around this point. So moving on then, the next point that I want to look at is best and reasonable endeavours. This again is a common clause that is found in consultancy agreements, and this can go back to the sort of warranty points, the scope of work point that we spoke about earlier. So best and reasonable endeavours, I've highlighted it specifically on the slide because often people are not sure what is meant by that wording, what is meant by that clause. So if you agree to a best endeavours obligation, how is that different to agreeing to a reasonable endeavours obligation? Now, this is an important point in the context of consultancy, because often you will see in consultancy agreement that either the consultant has to do the following, and then there'll be a long list of sort of obligations, so perform the services, comply with any reasonable instructions, whatever else may be in that agreement. It becomes an absolute obligation. Equally, it may say the consultant shall use best endeavours to do whatever they may be agreeing to do, so perform the services, whatever else has been agreed to do as part of the scope of work. The next stage down will be the consultant has agreed to use all reasonable endeavours to do X, Y, and Z. Now, what is the difference between all those three sort of steps? And again, often I will see businesses, I will see consultants who aren't entirely sure what it is that they are committing to when they do this. And often people think best and reasonable endeavours is the same. And I've even seen clauses where it will be the consultant shall use all best and reasonable endeavours. So it's kind of mixing the two. So it's just worth, I think, exploring now how this should all be dealt with. So an absolute obligation is always going to be the highest standard. And that is going to be an absolute commitment. So if you agree to do something, I agreed to provide the services to you on Wednesday. If I don't do that, and I provide the services on Tuesday, or I don't provide them at all, there is an absolute right to bring a claim against me for breach of contract because I have breached that absolute obligation. If I agree to use best endeavours to provide the services on Wednesday, and I don't do it, that is still a very, very high standard. And it means I would need a very good excuse to not have performed the services that I said I was going to perform in the time that I was going to perform them. It's a very, very high standard. So an example would be, and we might look at this later on when we get into the force majeure issues, but a good example is if there was ever a fuel crisis, a best endeavours obligation, and you couldn't get transport. A best endeavours obligation would still expect you to turn up at the right time, even if fuel was prohibitively expensive. So even if the contract was very uneconomic for you, a best endeavours obligation would still expect you to do that. A reasonable endeavours obligation would, however, take account of all the circumstances, would take a lot. So in that situation would think, well, hang on a minute, fuel's just not available, or it's completely uneconomic. Is it reasonable? You could say, well, I tried my best to get fuel, I just couldn't. It would be more reasonable. Reasonableness would be taken into account. And in that situation, it's a far, far lower standard. So what I suppose I'm saying in the context of consultancy is if you are giving warranties and you are warranting certain levels of performance, it's always going to be more favourable to you to use reasonable endeavours than it is to give an absolute warranty. However, the businesses that are going to sign you up are going to want an absolute warranty. And then it's that balance as to commercial negotiating power as to what you are prepared to do. Now, it may be that as a consultant, there are certain obligations that you are absolutely certain you can perform. And in which case, giving an absolute obligation or giving a best endeavours obligation may not be that much of a problem for you if it's something that you can easily achieve. So an example here would be perhaps in the sale of goods, if you were saying, I will pass on any manufacturer's warranty, something like that that's relatively within your control, something that you can do, that is not going to be a problem for you to do that. So you may feel comfortable giving an absolute obligation or a best endeavours obligation in that situation. Something that's going to be more challenging for you, you may want to look at giving a reasonable endeavours obligation. But again, it comes back to understanding what it is that you're committing to, and always making sure that you don't overcommit. So if you are agreeing to something, know that you're doing it with your eyes open and with a high degree of certainty that you are able to achieve that. So that's something that I would certainly consider and look at in the context of best and reasonable endeavours. Just be absolutely clear and certain what it is that you're signing up to. And equally, if you're getting in contracts from other people, be clear as to what that means. What is it that you're committing to? If they're wanting you to have an absolute obligation, then that is something that you need to consider on a case-by-case basis. So yeah, that's another point to look at. So I'm moving on now to one of the sort of key areas for any commercial contract, but in particular consultancy, and it's that of liability. So this is of absolute vital importance, and this comes back to what I said on the very first slide about this is the key area in which you will be able to manage your risk and reduce problems, reduce everything down. So I'm just going to start off by just setting out so that everybody's clear as to what I mean by liability clauses. They are very common, found in most commercial contracts, but again are often misunderstood. So what this liability clause is intended to do, we'll look at it from the point of view of you are the consultant providing services. what do you want in your consultancy agreement? Well, one of the key things that you will want is to reduce your liability. So a liability clause basically says that you've agreed to perform the consultancy services. That's all fine. However, in any area of life, there is always an element of human error and things that can go wrong. So it may be that you have agreed to provide the services on Wednesday. You think that that's all absolutely fine. You know that you've got a clear scope of work. You're happy to do it. And then for whatever reason, it just all goes wrong and you don't perform what you've said that you will perform. In that situation, you potentially face a breach of contract claim from the other side because you haven't done what it is that you'd said you were going to do. So you acknowledge that. So you're not in a situation where you're arguing about what's gone wrong and what hasn't, because you're openly admitting, yes, I'm sorry, I got it wrong. I should have performed and I didn't. For whatever reason, it is my fault. But the person that you have signed the contract off with, you are, in this clause, you are saying to them, I've got it wrong, but actually you can only bring a claim against me up to a certain amount. So even though I have got it wrong, I am still limiting my liability in this contract. I am not going to be liable to you for everything, forever and a day, for loss of opportunity, for a load of random things. And also, I'm only going to be liable up to a certain amount, and we'll look at what that certain amount should be in a later slide. But so as a concept, you're saying, I've got it wrong. I know I face a breach of contract claim, but I'm only going to be liable up to a certain amount. And in doing that, you manage the risk of your contract. And there's all sorts of things that you need to take into consideration when you're considering risk, you're considering liability. But from your perspective, as the consultant providing the services, it's always going to be of paramount importance that you don't sign off a contract where you have unending liability, because that means you've got unending risk. And the practical reality of that comes down to, if you don't have a liability clause and you face a breach of contract claim, you can then be sued for an unlimited amount. And often that unlimited amount can be way higher than your insurance cover, and unfairly higher than the benefit even that you have received of the contract. So the liability can run to way more than the balance that you have received from them as a result of performing the contract. So it's always really important to make sure that this issue of liability is nailed down. Even if you take the decision to go for a higher cap on liability, at least you've done it again with your eyes open, with certainty, and you know what it is that you are signing off. We'll look at the role of insurance later on, but often that is a good sort of test as to whether you have pitched it right, as to what your insurer says. Because if your liability cap is way out of step with your insurance, then obviously that is potentially a problem and something to think about. So that is just how, so that's the overview of what a liability clause is. Now, the difficulty that we have with drafting liability clauses, and the difficulty that you will have if you're reviewing contracts or you're considering liability clauses, is that, unsurprisingly, this is an area of law that has been heavily litigated, because people, if the relationship is broken down and the contract's gone wrong, this is the first thing that people will turn to. What is the cap on liability, to work out how much money they can recover. So there's lots of case law around this. The other complicating factor is that we have a statute, the Unfair Contract Terms Act 1977, that sets out guidance as to how liability clauses should be drafted and how they should be put together. Now, what this law says is that all liability clauses have to be reasonable in order to be enforceable. So the big question that everyone asks, the next obvious question, is what is reasonable in this context? And I often find that clients will say to me, can you just tell me what's reasonable? And unfortunately, there is no sort of clear, there's no mathematical equation, there's no formula as to what is going to be reasonable in any particular situation. It's all decided on a case-by-case basis. And what we as non-contentious lawyers look at is How have the courts decided this in the past? What do we think is going to be reasonable in the context of this arrangement? Now, a lot of the reasons behind why there's no sort of set figures is that it's very, very difficult when you're thinking about liability that can arise from different contracts. And there's all sorts of things that need to be added in that we'll look at the next slide. So just in terms of a drafting perspective, I've put on this slide that you cannot exclude liability for death or personal injury or for some fraud. Now, the reason why I have put that on the slide is because this is a question that I often get asked, especially if I'm reviewing contracts. Why is this liability clause so long? Why does it say, why has it got wording in referring to death or personal injury or fraud? Because we're not trying to exclude that. So why do we need to say it? Well, again, this comes back to what I said at the start about liability clauses being heavily litigated. The courts have said in the past that if you don't specifically state in your drafting that you don't have liability for death or personal injury or fraud, then there's an argument that you could actually be trying to exclude liability for that, which you can't do. And if you're trying to do something that you can't do at law, then the risk is that the entire liability clause gets struck out, which obviously is the worst case scenario because you're constantly trying to put yourself in a position where your liability clause stands the best chance of being enforceable. So that's the last thing that you want to happen. So therefore, the drafting style has evolved that in well-drafted liability clauses, unfortunately, they are always in quite a long form to pick up on all these points. And you will always see wording along the lines of nothing in this agreement purports to exclude liability for death or personal injury or for fraudulent misrepresentation. It'll be words to that effect anyway. And it's often picked up on and it's often deleted by people who just think this is just a waste of space, but actually it is there for a reason. So I suppose the message that I'm trying to get over today is if you see a long form clause, don't be put off. This is one of those areas that unfortunately can't be reduced in scope, and all the wording is there based on some previous case law. The other point that I just wanted to touch on before we move on to looking at more of the fine detail in liability is when you're getting contracts in or you're looking at contracts for other people or that have been sent through to you, don't always think that liability, because it's a key area, will be under a heading liability. Often liability clauses can be hidden in unobvious places, and you want to make sure, again, this comes back to understanding what it is that you're signing off on. You want to be absolutely certain that you're not missing anything. So even if it's not under a liability heading, if you are seeing words that attempt to exclude liability, if you're seeing the death or personal injury words, then you want to make sure that you understand what it is that you're excluding liability for, or that somebody is trying to pass liability on to you. So again, I would make sure that you look in places that it may not always be obvious. As I say on the slide, often it can be hidden within other clauses, and even it can be hidden in a schedule. So make sure that you are aware that everything has been read and that you haven't missed anything, basically. So the big question on liability. You've got your contract, you are putting together terms and conditions, you are having a think about what it is. So you're the consultant, you're thinking, what kind of terms and conditions do I want? How do I want to deal with my liability? So the thought process that you need to go through is bearing in mind what we said about UCTA previously. What is going to be reasonable? What are the kind of things that I should be considering about when I'm setting my cap on liability? Now, the clients that I see, understandably, often want their liability to be as low as possible. So they will often say things like, right, I want to completely exclude liability, and or they want liability at a very low level, and are often unfortunately disappointed when I will say, right, okay, if you do that, you run the risk that this entire clause will be struck out by a judge, and then you will have unlimited liability. So it's better to have a reasonable limit on liability that stands a good chance of being enforceable than it is to have a very low cap on liability that will just be struck out the first time it gets before a court, or even if it gets to the early stages, if a litigation lawyer looks at a very low cap on liability, they will know that it doesn't stand a chance of being enforceable, and therefore they will push for unlimited liability and therefore unlimited damages, which again is not what you want. So let's think about what is likely to be reasonable. So the first bullet point, what's likely to be reasonable? If you consider the losses that are likely or unlikely to be suffered by the other side. Now, so always thinking about, if you are providing the services, what losses, what could you do that could go wrong that could cause loss? So if we look at a few sort of examples, likely losses in a consultancy situation, depending upon the type of services that are being provided. So you're providing health and safety services, you're going onto somebody's site, you are potentially logging into their IT systems. What could go wrong is if you negligently infect them with a virus, brings down their entire IT system, and it's all down to something that you have done or haven't done. Now that is something that you could do that could cause them loss. You could also potentially cause them tangible loss. So you could drive to their premises and reverse into the office and demolish a wall. That is something that is direct loss. That is something that is foreseeable and is some type of loss that you could do. And obviously you will know the contract that you are signing up to. You will know what could go wrong and the potential liability and the damage that you could cause. So it's thinking about that level. Now, if your scope of work is very, very narrow, and you are doing something that you can't foresee a situation where you could cause them any loss, and it's a low value contract, you're not receiving a high monetary benefit for entering into the contract, then you will get away with a lower cap on liability than somebody who is performing high risk services, carrying a high level of insurance, and has got a scope of work that they know from the outset could provide, could lead to catastrophic loss. So it's always thinking about things on a case-by-case basis. What are the likely losses or the losses that are unlikely to be suffered? Think about the scope, think about what you could do that could go wrong, because obviously that comes down to the concept of reasonableness. It's reasonable in the first situation where you're not doing something that's of high risk, you're carrying a low level of insurance, to have a low cap. It's not going to be reasonable in the second situation where you're performing high risk activities, you're getting a high benefit from that contract, and you're carrying a high level of insurance. It's just not it's not as reasonable. The next thing to look at, or one of the factors to consider, is the bargaining power of the parties. Now, again, if you're an individual consultant, you may not have set up as a limited company, you might be an individual who's signing off this contract. You are coming up against a big PLC who are basically enforcing those terms and conditions upon you. That is an unequal bargaining position. And if you haven't got a high level of bargaining position, then it's more reasonable to try and go for a higher cap on liability. Again, there will be situations where the liability clause that's enforced upon you is so low that it's unreasonable in itself. And then you may take a different view and you may think, well, it's so low it would be unenforceable. But that's something to, again, it always needs to be decided on a case-by-case basis. But a relevant factor to think about is the bargaining power of the parties. If you're the party that's seeking to enforce terms on other people and you've got a high degree, you're in a niche market, there's only you that can do it, you are enforcing something on them, it's not going to be reasonable if you try and enforce something on them that's unreasonable. The next bullet point on the slide is insurance. Now, this is an absolute key area that I think is something that should always be considered. I can't think of a situation where you wouldn't want to think about that, the role of insurance. So how does that work? Well, it's a good idea often to speak to your insurer specifically about contracts that you're thinking of entering into. And it's really important to make sure that there isn't a big discrepancy between the insurance that you're carrying and the liability clause that you've got, sort of either way. So you don't want to be in a situation where you are signing off contracts and you're capping liability at, and these are just simple figures, you cap liability at £5,000, but actually you're carrying insurance of £10 million. Well, obviously that's a huge gap, and a court would look at that and say, well, why is there this big discrepancy? Why is there this big gap? You clearly have envisaged a risk of up to £10 million, but you're trying to get away with a cap of liability of £5,000. That doesn't seem fair, that doesn't seem reasonable. But equally, you don't want it the other way around. You don't want to be, which is the worst way around from the point of view of the consultant providing the services, you don't want to be in a situation where you are providing, you're providing services, you're carrying insurance of 1 million, but your cap on liability is 10 million. Because then, of course, where have you got to go with it? If you do face a claim, you've got this massive gap between the risk that you're carrying and the insurance that's backing it up. So again, all these factors go to reasonableness, and from the point of view of the party providing the services, insurance is a key way of managing your risk. So you do need to make sure that it all stacks up and the figures match and it all ties together, because otherwise that can lead to serious problems. The other thing on insurance that I would urge caution on is that certain insurers have got different names for the different types of insurance. So different insurers will give different terms and conditions depending upon the name of the policy. So I would always look at the figures for insurance rather than what that policy is called. So employers' liability insurance, public liability insurance is relatively straightforward. But when you start getting into things like professional indemnity or management insurance or contract insurance, that's when you need to be very, very clear about the scope of the insurance to make sure that you're not agreeing sort of a cap on liability with an insurance policy that doesn't actually meet it isn't the right scope, that doesn't meet the correct parameters to actually protect you in terms of the services that you're providing. So I suppose the key take-home message from that is you sign off contracts and you're dealing with insurance, always keep your insurer in the loop and make sure that you're confident that you have that protection in place and that you're confident that your insurer knows and understands what it is that you're entering into. So I often suggest to sort of clients that I'm dealing with that they even send a copy of, if not the full contract, then certainly the liability clause to their insurers and their insurance clause to make sure that they've got it covered off. The other thing to bear in mind, of course, is that if you are providing services, often the business that's engaging the consultant will want to actually see their insurance policy. And sometimes in drafting, there's things that are co-named and other bits and pieces that you need to think about with insurance. So the way around it and to reduce risk is to make sure that you always keep your insurer sort of involved and up to speed with that. So in summary, when deciding what is reasonable, key points. There's no defined mathematical formula for what's reasonable. It's always going to be governed by UCTA, the Unfair Contract Terms Act. So everything has to be about reasonableness. And you need to consider this on a case-by-case basis. So in terms of if somebody was going to ask the question, what is reasonable in the context of consultancy, I can't give an answer to that without understanding the full parameters, the scope of the contract, the risk involved, the bargaining powers, the role of insurance, all these things that I've said all go to make the answer. So they all do need to be considered. So really case-by-case basis is how it needs to go for liability. So finishing off on liability, the final things that I wanted to cover, and this comes down to the type of loss. So we've been through the concept of reasonableness, we've spoken about what the liability clause is, what are the types of loss that we are talking about. There are two key types, and again, if you are seeing contracts, if people are sending contracts to you, you will see this come up time and time again. If you are looking at drafting contracts and you are looking at putting your own terms and conditions together, if you've got the help of a lawyer, then absolutely brilliant. If not, then these are the things you want to be looking at. So what are the types of loss that you are trying to protect against? So there's two types, indirect and direct. And these often come up in the drafting of liability clauses. So, and we need to think about reasonableness as well. They're often drafted in a long form. And the reason for that is, as I've said previously, it's all based on litigation, and it's all around this concept of reasonableness to make sure that it stands the best chance of standing up. This is why you tend to see long form drafting in this area in particular. So what is a direct loss? If we go back to the example that I gave sort of briefly earlier about it, direct loss is something that is foreseeable. It is a direct consequence of performing the contract. So you are a consultant, you are driving in your work vehicle to go and provide the consultancy services at somebody else's premises. You lose control of the vehicle and you drive in to their factory, warehouse, office, whatever it may be, demolishes the front wall, which means that that building can't be used. The direct cost, so the direct loss that you have caused in that situation, is the cost of rebuilding that wall. So putting it right, making good, it is the cost of putting that back to how it was, as though you had never caused the loss in the first place. That is the direct loss, because it's a direct consequence of something that you did in connection with the performance of these services. It's something that they have lost directly. An example of an indirect loss would be you demolish their business premises, so they're not operational for that day. An indirect loss, or something that is not foreseeable by you, would be if they tried to run an argument saying, for example, well, if our office had been in operation that day, we would have won a particularly lucrative contract, but because the person couldn't visit, because we didn't have an office, we couldn't negotiate that contract, and therefore you have cost us money. That is an indirect loss, because it's not something that you could have foreseen. And it's not a direct consequence of something that you've done. It's not because you've demolished the wall, it's indirect from that. It's not a direct consequence flowing from that breach. It is something that is further removed. Now, that is not to say that businesses aren't very keen on recovering indirect losses, because they will always want to recover any loss that they've suffered, not just direct loss. But it is normally considered reasonable in the context of liability clauses to allow an exclusion of indirect losses. So normally, how liability clauses will be structured, it would normally be considered reasonable to cap your liability for direct losses, so the things that are foreseeable, up to a level. The indirect losses, the things that aren't necessarily foreseeable, you would try and exclude those where you can. Now, the overlap comes in things like loss of profit, that unfortunately can be both direct and indirect. They can be a direct consequence of something that you've done, but they can also be indirect. And it's important in the drafting to make that distinction. And again, consider on a case-by-case basis what is the right thing to do in that particular situation, and insurance and all the other things that we've spoken about. So that's a quick run through of the types of losses. I'm going to move on to indemnities now, just to cover off, because again, this is a common example that you will often see, particularly in contracts that are being imposed on you. In consultancy arrangements, you will often see indemnities in there saying that you will indemnify the business for any loss that they may suffer as a result of your performance of the service. And that basically means, so what an indemnity is it is based in summary, it's a pound for pound compensation of the losses that they have suffered. Now, from your point of view, if you are the consultant, you don't want indemnity. If you're the business signing up the consultant, you probably do. And that's where you get this conflict. Indemnities are different to sort of normal contractual breach of contract claims, because they're a higher level. They're almost like a promise that you will compensate them for things that you've done wrong. And unlike contractual damages, indemnities, there's no concept of sort of remoteness or mitigation. So the person that's got the benefit of an indemnity, there's a strong argument that they don't have to mitigate their loss. So an example in that context is you've done something wrong. They can, in the wall example, they don't have to mitigate their loss. They can just go out and buy the most expensive person to fit it right, and they don't have to hurry up to do it, and they don't have to mitigate. So that's why indemnities are so sort of dangerous in this context. So how should you deal with them? Well, obviously, if somebody's trying to impose an indemnity on you, you should try and resist. If you are the person who's appointing the consultant, then you should certainly try and get one in your favour. All businesses normally try and push for them. Some indemnities are standard. So again, we haven't got time to go through the full where it would be standard, but often in an employment context, in certain well-drafted intellectual property provisions, indemnities are relatively common. But normally you would want the standard advice is to try and resist. If you can't resist and you're in a weak negotiating position, or you want the business, or there may be some reasons why you can't resist, try and, if possible, include it in the cap on liability. So all the things that we spoke about earlier, please do try and include it on that, because at least then if you are giving an indemnity, you're not saying for forever and a day you'll be liable. You at least have got hope on the horizon and a cap there that makes it certain, and that helps with insurance as well. So that's sort of how you would see one if it came to you. And again, there's other sort of tactics that you can use, just finishing off on how to manage. So you would try and cap it to a monetary amount if you can. I mean, again, this is worst case scenario where you can't delete it. The standard advice, or my advice, would always be try and delete if at all possible. This is only if you're in the situation where you can't delete it that you would look to try and take these further steps. So you would try and cap it at a monetary amount. So you would say, yeah, okay, fine, I will indemnify you, but it's only up to, I don't know, 80% of my insurance cover, or an equivalent financial limit. You would try and make it subject to reasonableness. So if you can't delete it, you try and make it as reasonable as possible. So put in wording that they will act reasonably, that both parties will act reasonably, to try and it will only be reasonable legal costs that they can recover. Try and incorporate the concept of reasonableness wherever you can. And also another thing that to bear in mind with indemnities is that if it references legal and professional fees, you would always try and exclude that if you possibly can. And again, if you can't exclude legal and professional fees, because obviously they can be quite expensive, you want to make sure that you've got this concept of reasonableness and an overall cap, if at all possible. But we're talking now in the worst case scenario. As I say, starting point will always be to try and make sure that it's removed. So, force majeure. Moving on to this, another standard clause. I say it was standard. If I'd been given this webinar, say a year ago, I doubt that force majeure would have featured when I've got to try and narrow down sort of the main points. However, because of the situation we are finding ourselves in at the moment, force majeure is really the hot topic of the day. So I did want to make sure that it was covered off for you. Now, force majeure appears as a very, very standard clause. I'm sure everyone is familiar with it. You'll have seen it in most contracts, and it's basically intended to cover the situation where if there is something catastrophic that happens, so an act of God, something beyond either party's reasonable control, neither party is going to be in breach of this contract. So again, I perform the services on Wednesday. If there's been a flood or a fire or something terrible that means you can't do that and it's affected everybody, then it is not fair that you should face a breach of contract claim because you can't perform. Because force majeure is something that is beyond any party's possible control and they can't be facing claims for it. Force majeure provisions are normally dealt with in a way that the situation is managed. So normally you will have a definition of force majeure that will include act of God, fire, flood, riot, sonic boom, all these other things that are beyond anyone's control. And then you will have an operative provision saying that neither party is in breach as a result of force majeure. And then you may have a clause saying how you will manage the force majeure event. So it will be things like each party will tell the other party within 7 days of the force majeure happening what's going on, what the plan is, all that type of sort of administrative wording. And that can run to quite a few paragraphs if it's in a detailed contract, or it could just be a we will notify type clause. And then ultimately there'll normally be a long stop date. So there'll normally be, if the force majeure continues for say 3 months, 6 month period, whatever is set out in that contract, then the parties can bring the contract to an end. And that's to stop the situation of basically the contract just hanging. Now, the difficulty that we've got at the moment is that we are in the midst of a global pandemic. But it's quite an unusual situation in that some businesses are managing to carry on as normal. So is that a force majeure event for them? But then other businesses are absolutely scuppered in that they can't function at all. So example of pubs, nobody's working in a pub at the moment. That is because they have to be shut. That is a clear force majeure event. But for my work, for example, I'm able to work from home. So I'm pretty much carrying on as normal, just with slight variations. So it's not really a force majeure event for me at the moment. The reason that I'm mentioning this is because if you are signing off a contract at the moment, it is really worth thinking about how you want to deal with this situation. Because if you are signing off a normal force majeure clause, then potentially you could be in breach, you could be invoking that clause the day after you've signed it, because we are in a force majeure situation. So the message for now is just be aware of this clause at the moment and make sure that you have got wording in that adequately deals with the current situation to avoid having to rely on force majeure the minute you sign the contract off if it doesn't apply to you. And there's lots of compromise wording that I'm putting in contracts at the moment that would cover off that issue, that will deal with this. But for you now, if you're looking at contracts or you're putting terms and conditions together, just be aware of this. And it's certainly worth, if somebody is imposing terms on you, it's certainly worth raising with them, well, what's their interpretation of the global pandemic? How do they want to deal with this clause at the moment? So I will just whiz through assignment, just because, again, this is standard clause, but in the context of consultancy, it's worth just having a think about. The reason that it's relevant here is that I'm imagining sort of in your sector that there will be situations where the consultancy arrangement is very personal to an individual. In that situation, you just want to be aware of the effect of assignment, and to make sure that you have just considered the impact of sort of, if it is you personally that are providing the consultancy services, you don't want to be getting into the situation where the contract can be assigned. So have you considered, will you allow a substitute? Should that be built in? How will you deal with that situation? And again, it's worth a conversation, it's worth a discussion, to be clear as to who the parties to the contract are, and to be clear as to who can actually perform these services. So that, again, you avoid any problems, avoid any disputes, because it's clear who can provide the services and if a substitute can be appointed or if they can't, and when the contract can be assigned. So again, standard clause, but in this context, do consider it carefully. Now, I'm just whizzing to the second last but one slide, and this I just wanted to deal with before we sort of start signing off. And this is how to deal with third-party terms and conditions, because as I've alluded to throughout this this webinar, the majority of the speaking that I've done has been in the context of the consultancy providing the services and being in a position of perhaps control, where they are drafting up terms and conditions, they are looking at creating their own terms and conditions, and they are looking at imposing their terms and conditions on sort of third parties. It is very, very common, however, that a consultancy arrangement will arise and you, the consultant, will have your own terms and conditions, but actually the business will say to you, no, we're not happy to deal with you on your own terms and conditions. These are some terms and conditions that we are going to impose on you. So you will not have a choice about this. If you want our business, you will have to sign up to our terms and conditions. So it's what should you do in that situation? If you want the business and there's no negotiating with them and they just say, this is it, take it or leave it. And sometimes there may be valid reasons for that. They may run arguments that they want everybody on the same set, their insurance is geared up to having everybody on the same terms and conditions. There may be other considerations, and it may be acceptable to you. So what should you do in that situation? Well, the best way is always understand what it is that you are signing up for. So you should always review, consider and understand before you do anything else. Now, if you feel you are in a commercial position to try and negotiate, then you should highlight, once you've done the risk assessment, you should highlight what are the key terms that you want to push back on. What are the key things for you? And if you can identify, say, 1 or 2 points, you're more likely to get that through than if you go back to them with an entire rewrite. So at a minimum, I would always say if terms and conditions are sent to you, you need to undertake a full risk assessment, identify the key points and try and push back on that if at all possible. So moving on now then, this is my final slide and this is the conclusion. So just drawing all that together, obviously it's been, I appreciate that it's been a bit of a whistle-stop tour. Obviously some of the issues that I've covered today would be whole year-long liability, would be a whole series of seminars if you were doing a law degree at the moment. So I've tried to cover it off as sort of quickly as I can. So what should we draw from this today? Well, first thing is, always try and document in contract if possible. Don't rely on sort of email exchanges between you, oral correspondence. Always try and document. And the reason why I say that is for the reasons I set out on one of the earlier slides. It reduces risk, it creates certainty, it avoids dispute, it avoids ambiguity. There's a whole range of benefits, but the key thing is always managing risk, trying to put yourself in the best possible position. Scope of work is crucial for the reasons that I said earlier. If you don't get anything else right, then at least be clear as to what obligations you're signing up to. So always think about having a good scope of work and really create certainty. That's sort of one of the main messages of today. Anything that is ambiguous, that is vague, you're lucky if it doesn't lead to the parties falling out. So good contract management, set it all out up front, agree what you're going to do, agree what they're going to do. Hopefully it will be a strong working relationship, everyone will be happy. And remember, you only look at the contract when it's all sort of gone wrong. So hopefully you would set all this out and the business would go so well that you would never look at it again. But it's like your insurance policy. When it does go wrong, that is when you get the absolute benefit.